promise you, oh Jesus, a happy golden good soul that I'll never touch the shit again if you let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am. I didn't mean to. I'm terrified.
Tired of guns, tired of people being shot, tired of it. Jefferson County's tired of it. I'm going to deny the motion. Your bond will remain at $300,000. If it's not already a condition of your bond, I am now making it a condition of your bond. Mr. Rojas, you have Glenda Williford. Good morning.
Sure, Ben.
Thought I saw somebody steal some coffee earlier.
It wasn't me, somebody spilled all my stuff.
Good morning, ma'am. Are you Glenda Williford?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Give me just a second to get that pulled up.
Our agreement, Your Honor, is for her to be on special needs safety.
Thank you. All right, it's taking a minute for my computer to get pulled up
We're on
here.
Lou's level this morning, Your Honor.
Okay, so Ms. Williford, in cause number 24 DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges
Judge, we've agreed to go on counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand, if I follow this agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today, and is that the recommendation from probation as well?
Yes, ma'am.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
There we go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. It looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had a statement prepared for you, explaining the only reason I was doing marijuana at this time is because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never touch the shit again if you let me go home.
Are you seriously going to stand here and talk
No.
like that?
No, ma'am, I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I'd get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to.
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff.
Actually, that went better than I thought it would, actually.
Really?
This is one of those times it's great to have on camera.
Oh.
She's never seen me. I'm literally biting my tongue.
You just never know. What?
Jesus is what? Freaking.
I mean, you use the F word and Jesus in the same sentence. I feel like that's a problem.
She said friggin'.
Well.
You know what she meant.
I know what she meant.
Good morning. Are you Brian Trejo?
Yes, ma'am.
And this is 26 VCCR 0132. Mr. Trejo is charged with aggravated assault with a deadly weapon. Mr. Rojas has filed a motion asking that I reduce bond, which is currently set at $300,000. And Mr. Rojas, you may proceed. Proceed.
Could you state your name for the court, please?
Sure.
What's your name?
Brian Trejo,
And Brian, how old are you?
18.
And where are you originally from?
Galveston.
You were born in Galveston?
Yes, sir.
Where do you live now?
Port Arthur.
You lived your whole life in Port Arthur?
Yes, sir.
Okay. Who do you live with?
My parents.
Your parents, and your parents started together, and they're here today, right?
Yes, sir.
Okay.
Sorry, say that again.
They're here today, or his parents are here today. Who else lives in the house with you?
My brothers, my siblings.
And a lot of them are here today also.
So,
Brian, you know, your bond right now is $300,000. Your family's having a hard time coming up with the money for that bond, right?
yes, sir.
Okay. Well, I want to talk about you personally. Do you own any property in your name?
Yes, sir.
A home, a car, any land or anything like that?
Yes, sir.
Do you have a bank account in your name? Okay. My understanding, and tell me if I'm wrong, your parents own the house that they live in, right?
Yes, sir.
And it's already paid off.
Yes, sir.
Okay. And they're willing to help you out as far as trying to get you get some money for the bond if it doesn't get lowered. Have you ever worked?
Yes, sir.
What kind of work have you done?
I work with my mom.
Doing what?
She cleans apartments, offices, houses.
Okay. Is that the only kind of work you've ever done?
No, the yards. I've done construction.
You did construction with a company or working with a family member? Or what?
Yeah, family.
Okay. And all that kind of work, the construction work, cleaning offices, is that work that's still going to be available to you if you're able to make a bond?
Yes, sir.
Okay, and that's something you want to get back out and start
Yes,
working
sir.
to help pay for the bond if we're able to get it low.
Yes, sir.
This is a serious charge, right?
Yes, sir.
Is this, you're only 18, is this the first time you've ever been arrested?
Yes, sir.
Even as a child, you had any juvenile cases? As a juvenile, were you arrested?
Yes, sir.
For what?
Unlawful carry.
Okay. And you're asking the court to lower the bond. We're asking for a $50,000 bond. I think that'll be enough, and along with any, if the ankle monitor or any kind of other conditions that the court wants to put on it. You're asking the court to do that, set that, and you think that's a reasonable bond, right?
Yes, sir.
What else were you arrested for as a juvenile?
Is it
Drug case?
possession of marijuana?
Yeah.
Speak up, please.
Possession of marijuana.
Thank you.
And what kind of weapon were you carrying when you were arrested as a juvenile?
Um,
Was it a handgun?
yes, sir.
And that's what you're charged with here is for shooting somebody. Correct?
Yes, sir.
Another question, Your Honor.
No further question.
Any other witnesses?
No, Your Honor.
Mr. Rojas, go ahead.
Yeah, Judge, I understand this is a serious allegation. He's a young offender, and obviously the handgun gives concern, both two different cases with handgun, and I understand the court's concerned with that. He's a lifelong resident of Port Arthur. He's not going to flee. He's doesn't have anywhere else to go. His family lives there. They own property. They own a home that they live in. They're not going to go anywhere. We think if you set the bond at $50,000, that's something the family will be able to make. And if it's at $50,000, they also, I would imagine the court's going to want an ankle monitor on this, and that's something that allows them a little bit of money to pay for the ankle monitor as well. You can set it at $50,000. And that's what we're asking the court to do.
Thank you, Mr. Rojas. Mr. Nichols?
I don't feel that $50,000 is sufficient to protect the community for someone who's been arrested for carrying a gun and is accused of having shot somebody at 3 o'clock in the morning. The allegation in this case is that he and some other individuals followed a young woman home from her place of business where she worked as a waitress and were harassing her, and then ended up shooting her boyfriend who confronted them. So I think $50,000 is quite low and not sufficient enough. Your Honor, I'd ask that you said something much higher.
He was a driver.
So I am taking judicial notice of the court's file, which includes a copy of the probable cause affidavit. The fact, Mr. Trejo, that you've already been arrested as a juvenile, which wasn't that long ago, because you're what, 18 or 17 right now?
18.
18. And I'm not sure what you were doing out at 3:30 a.m. In this situation, but it gives me great concern. Tired of guns, tired of people being shot, tired of it. Jefferson County's tired of it. I'm going to deny the motion. Your bond will remain at $300,000. If it's not already a condition of your bond, I am now making it a condition of your bond, if you make it, that you will be required to wear a GPS monitoring device and be on house arrest, if you're able to make that bond. And we'll reset the case for an announcement and get it taken care of as quickly as we can. You can go back with the bailiff.
Thank you, Your Honor.
All right, sir, you're Lively Stratton.
Yes, ma'am.
And this is 19-33601. Mr. Stratton is charged with capital murder of multiple persons. Mr. Bradford has filed a writ asking for a bail reduction. I think we talked about this and reset it so that the state could bring any witnesses, and then I would make my decision. Mr. Bradford, do you have any witnesses?
Yes, we call Lively Stratton for the purposes of this hearing only.
Best you can, sir. Please raise your right hand. Do you swear or affirm the testimony in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Go ahead, Mr. Bradford.
Can you state your name for the record?
Lively Stratton.
And Mr. Stratton, you are the defendant in this case, is that correct?
Yes, sir.
And what is your bond currently set at?
I think after the appeal, I don't think my bond was ever set.
So it's your understanding that you have no bond at this time?
Yes, sir.
What was your bond set at prior to your trial?
I think it was $1 million bond.
Okay. And prior to this incident, have you ever been convicted? Well, you hadn't been, this conviction was overturned by the Court of Criminal Appeals, correct?
Yes, sir.
And prior to this incident, were you ever convicted of any crimes?
No, sir.
Where did you live at this time?
In Beaumont.
In Beaumont, and did you have a job?
Yes, sir.
Okay, how long have you been incarcerated?
Going on 7 years.
7 years? So do you have any substantial savings or any monies that you have collected?
No, as far as my bond, everything would be no contributions from like friends and family.
And if the judge were to set a $250,000 bond, do you think it's possible that you had family members and friends that could make that amount?
It'd be a stretch, but I think it'll be possible.
Pass the witness.
Any questions?
Mr. Patton, tell me about the means that your family has. What do your parents do? What kind of assets do they have? What kind of income do they have?
Well, my mom, she gets Social Security disability. My uncle, he's been a professor for the last 30 years. So I'm pretty sure he's got a good amount like saved up in travels and stuff like that.
Do your parents own their homes?
No, man.
Do they have cars? Does your uncle own his home?
He probably does as well.
And he's a professor at Lamar?
No, he lives in another state.
So would you agree with me that amongst the members of your family, you have considerable means to try to post a bond?
I wouldn't even say considerable because, I mean,
My uncle was really like kind of tight as far as his money wise. So it'd just be an if, even if he feels like doing it for me.
I don't have anything further, Judge. And before beginning, Judge, I asked the court to take judicial notice of the trial that you presided over some years ago, which gave you obviously a very good insight into the totality of the circumstances and the facts involving this case, and that there were 4 victims of this case. So just ask Detective Coffin, would you state your name for the record?
My name's Frank Coffin.
And were you one of the lead detectives on the case State versus Lively Stratton?
Yes, ma'am, I was.
And that involves the homicide of 4 individuals here next to Lamar campus here in Beaumont, Jefferson County.
Yes, ma'am.
And you were involved heavily in the trial process, preparation, et cetera, and you know what came before the court. Is there anything that you would like to add for Judge West's consideration with respect to a bond being set for Lively Stratton?
Well, Judge, I don't know that I nor Beaumont has seen a murder like this before, where 4 people were gunned down so close to a college campus, so carelessly, so quickly. And I can't recall anything like that before. So I think that in itself states that's a significant event as far as murder is concerned.
Detective Coffin, based on all of your years of training, experience, investigation of homicides, et cetera, do you feel like Lively Stratton presents a significant threat to the community of Beaumont if he is released?
Significant threat.
And do you feel like based on the totality of all these circumstances, there's a great likelihood of his flight if he is released from custody?
I would imagine that there would be, if knowing what he's faced with, knowing the amount of time that he'd already been sentenced to prison, the time that he can be sentenced again, there's no upside to not leaving.
I don't have anything further, Judge, unless the court does from the second.
Oh, you have to ask questions. I'm sorry.
Detective Coffin, you testified at the trial, is that correct?
No, I didn't.
You did not? Did you observe the trial?
I did.
Okay.
Well, no, I did not.
So you didn't watch the trial and you didn't testify at the trial?
No.
Okay, so you don't know what happened at the trial?
I was not there for the day-to-day, but I do know what happened. I was here at the courthouse helping prepare with evidence, with witnesses.
But you didn't watch the testimony, did you?
With interviews. I did not watch the individual testimony.
Were you aware that the jury found that 2 of the victims evidently that they didn't convict him of killing the 2 guys with the knives? They convicted the 2 guys without weapons. Were you aware of that?
I'm not aware of the details of how many people or of how he killed each person, no.
Okay. That's all I have.
Anything else?
No, Judge.
All right. Thank you, sir.
Thank you, ma'am.
Ms. Malvino?
Judge, I would ask for a bond in this case that is equal with what the facts of this case are, with the fact that we have 4 homicide victims. I think an ask of $250,000 is extremely low. I think it's offensive to the court to ask for a number like that for all 4 individuals, maybe $250,000 per individual. So that's back at the $1 million bond that he was originally set on. The court, unfortunately, is required to set bond on multiple murders in Jefferson County on a quite frequent basis these days. And I think something in excess of $1 million is more than a reasonable ask in this case.
Thank you, Ms. Malvino. All right, so taking into account the testimony of the prior trial that I did preside over and argument by counsel, I'm going to grant the writ and set bail. I am going to find that bail in the amount of $1 million is appropriate for the nature of this offense and in line with what I know about the case and the argument. If there was bond made, there would be a GPS monitoring device required and house arrest. I would obviously, if that bond was made, need to know what that address would be. And then we will get the case set for an announcement and then move it to the trial as quickly as any of you guys are ready to do that.
Yes, ma'am. And Ms. Paul, this is your initial appearance in cause number 25, DCCR 1792. You're charged with the third-degree felony offense of stalking, and that's from October 3rd of 2020. Stand up. What's the matter?
Nothing. My allergies.
Okay. I tested you this morning. You didn't have anything in your system?
No, ma'am, but I just sneezed back there.
Okay, let's double check it. Have a seat in the jury box, please. So, Ms. Paul, I received a note that you refused to take a drug test.
Yes, ma'am, because I leaned against the thing. I just finished sneezing back there, and I felt like I was being singled out. I know I have alcohol in my system
So
from
here,
the night before.
so let me explain. If you don't test
Mhm.
and let me see what is or is not in your system, I'm going to assume that you're positive,
Okay.
and I will raise your bond for sure, and you'll go to jail.
Okay.
So do you want to take the test and let me see what's in your system?
I don't have anything in my system besides alcohol.
Then go take the test.
I can't pee.
We're going to give you some water.
I just had water.
Then you want me to go ahead and send you to jail?
I don't know. You haven't even finished running down my charges to me.
What?
Running down my charges to me.
What do you mean?
What I was here for, or if I'm going to get a lawyer, and all that.
First things first is I'm ordering you to take a drug test. If you refuse the drug test, then you're refusing a court order, and I'll raise your bond and you'll go to jail. Then you'll have an attorney come visit you in jail, and they'll go over all of the charges. If you want to take
So
your
I can
time,
bond out.
yeah, your bond's going to be raised though.
But could I bond out today? That's what I'm asking, because
You don't know what I'm going to set your bond at
I'm
yet.
trying to go to
You're-
work.
Well, then you should probably take the drug test.
Just try.
Because the more you refuse to do it, the more concern I have, and probably the higher your bond's going to be.
I'm just worried about getting back to my kids and going back to work because
Then take the drug test. So either there's something in your system other than
I have
alcohol.
something in my system. I
Right.
said that.
You said you have alcohol.
Yes, ma'am.
I'm not worried about that right now.
Maybe some weed.
Take the test. Let me see what's in your system.
Just weed.
Okay. I want to see what's in it. Take the test. And then we'll decide. Just because you test positive does not necessarily mean that I'm going to raise your bond, but we're going to have some discussions depending on what's in your system. So if you want any opportunity today to walk out that door instead of that door, go take the test. Otherwise, I'm raising your bond right now.
I can sit and see if I can pee.
Go try. Justin Wallace with Mr. Lewis. Okay, so you've refused again.
I didn't refuse. I told them that I couldn't go. I
Well-
didn't refuse for the sec.
There's no way that after a couple hours you can't go a little bit. So I'm going to find Miss Paul based on your, number one, that you told me that you smoke marijuana. You told the man in the back, the drug tester, that you smoke daily, and that you used alcohol also yesterday, which alcohol's I'm not so worried about unless you're driving, but obviously using marijuana is a violation of the law, which means it's a violation of your bond conditions.
Okay.
And so let me see something real quick. Your current bond that you I need to take a look at probable cause affidavit. Give me just a minute to get you more information about you and your case, and then I'll decide what to set your new bond at.
Miss West, can I say, I know that I'm going to jail today. That's fine. But I feel like I've been the victim in this and I have the proof. I'm just overwhelmed at this point with the whole situation. Well, because the girl is still harassing me.
Have you called the cops?
No, but I have the proof of her going to my job recently. Letters from my job and her job.
All right, just hold on. You're going to need to tell all that to a lawyer. You still have that assault down the hall pending?
I have to go to that courtroom for the same person.
All right, so based on the limited information that I have,
Procedure. Jeez.
I'm going to again find that you violated the conditions of your bond and in cause number 25 DCCR 1752, raise that bond to $35,000. A condition of that bond, if you make it, is that you have to have a drug patch put on within 24 hours of your release from custody.
Okay.
And obviously, if you get out soon, I'm going to assume that that drug patch will initially be positive,
Okay.
but it should be going down. So
Okay.
it doesn't just test whether you're positive or negative. It gives me an amount.
Okay.
And if it's not going down, then that bond's going to go up even higher. Do you
Okay.
understand?
Yes, ma'am.
If you don't get the drug patch changed every 2 weeks like you're supposed to, some people say, oh, it fell off. And they don't just fall off. Okay. So you need to make sure you have it on at all times. Get it tested when you're supposed to. If you
Okay.
make that bond, go back with the bailiff.
Okay.
Good. You're Robert Felix.
Yes, ma'am.
And come on up, ma'am. Let me get this pulled up here. Good. And let's see, this is 21-38610 and 21-38611. Mr. Felix is on probation in each of those cases, one for manufacturing or delivering a controlled substance and the other for felon in possession of a firearm. I received an administrative hearing from Ms. Shoppa Bradley, and in it, the request was to schedule it for a judicial review. So you were in custody and released December 18th, and the stipulation was that you have a GPS monitoring device with zero tolerance. And it looks like there have been several issues with that monitoring company, that the battery either hasn't been charged properly. It looks like you were out past curfew. January 2nd, on January 3rd. Also, claim that you have unstable housing, but you're supposed to be giving the information of which of the addresses you're staying at to your probation officer each day. Is that correct?
Yes, ma'am.
So what's going on?
I really don't know what the address I'm staying at. Anytime I was out past curfew was because of work purposes. I was doing that. I gave her the receipts of proof for that. I have a job right now, Sparkling Image, looking on my CD.
At where?
Sparkling Image Wash Depot, and I also DoorDash. I've been on this monitor for 5 years, Judge. I paid over $14,000 since 2021. And the monitor wasn't really hindering me doing what I need to do. And I make the curfews. I lost my house and everything. That's why.
Here's the thing. This was your. Hold on. For you to say that this is a hindrance to you and an imposition on you does not bode well with me. Hold on. All right. You're on probation for obviously 2 serious felony cases. You have some criminal history, obviously, because you're on probation for an unlawful possession of a firearm by felon. I get that probation's not fun. I get that you have to do things you don't want to do. That's what happens when you commit felonies. So coming in at that angle is not going to go well. Okay. You've had some issues. You were here and we required that monitor for a reason. And so I'm trying to look back and see, but I'm guessing the reason was that we had some issues with failure to show up, or what was the?
We initially did a judicial review there were some problems with the monitors and getting them to comply. We asked for a judicial review to see if he could get off of it, and he didn't show up for that hearing. And so that's what put him in jail. And then he did get out again. He initially had some trouble keeping it charged and everything, but once it was impressed upon him that this was not going to go away, of what he needed to take care of. The only problem is it's not feasible to have somebody that has unstable housing do a monitor, and while he's door dashing after 8 o'clock at night, I've checked his receipts. He does DoorDash. He's got receipts saying that he has, I didn't check every single one, Judge, but I've spot checked, and he's doing it. He's going to school, but this monitor is not acceptable way for me to try to supervise him.
Okay. So do you think it would be easier for him that you could actually supervise better without it?
I do.
Okay. All right. And here's the thing. It sounds like, Mr. Joseph, if you had the other time you were supposed to be here, that was probably what was going to happen. And then I got mad that you didn't show up, and I'm going to make you keep the GPS. You see, the consequences just get worse and it could have been better.
I showed up last time. They sent me to a different courthouse in Port Arthur. I had the paperwork and everything. I've been screaming for years. I've been doing it.
You've been coming to, what court you're supposed to come to when it's my date for you to come to court, because you've been coming since you've been on the probation. So that's not, if there's an issue here where you're supposed to be.
I just followed the last directive order. They sent me to Port Arthur.
Who's they?
I had the info.
So here's the thing. Things are going kind of well for you. You probably should quit coming up with excuses. Okay. Because it's probably one of my number one pet peeves. It's just to keep coming up. Just take the personal responsibility. Went to the wrong place. Should have asked a bailiff. You know where the 252nd District Court is. You know the judge you're on probation for. So I'm going to, it sounds like you've got some really positive things going on, and that you were in a bad place and you're working hard to get out of that. This isn't meant to make it harder on you, but you have to follow the rules, and you have to show up, stay in touch. It sounds like your probation officer is willing to work with you through all of this kind of turmoil, but you not having a steady place to live. So take advantage of the fact that you've got a good one that's willing to work with you. Make sure you stay in touch with her. Let her know where you're staying. I know that's difficult, because if you're changing places, you got to keep telling her, but keep doing all of that. You're going to be fine. Okay. So I will allow the order that the GPS monitoring device be removed. That makes it all the more important, though, that you stay in touch and she knows what you're doing, where you are, and all of those things. Okay. All right. You're free to go.
Mr. Whitmire, in cause number 25, DCCR 0057, you're charged with a second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Revokes? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance, sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm going to sign a dismissal as part of this plea agreement, and cause number 25, DCCR 0056. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Just thinking about yesterday, and this is a possession case, so I'm not sure how it applies. But because of the judgment entered against you, you could be ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas and read that document carefully. All right, you can go back with the bailiff.
Thank you.
See, and so am I going to have to start? And this is cause number 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And 26 DCCR 0385 charged with assault of a public servant. And what is the announcement?
Yes, he wants to trial. I've conveyed that.
Is the offer, let's see,
Judge, he had previously rejected 15. I re-urged that today.
Okay.
This is their first appearance with this newer charge
right.
that was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent.
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct, which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that?
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? Yes. And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was wanting time though to hire an attorney. My people are going to give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible because I'm going to move your cases to the trial docket. Yes. Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared when that trial day comes up. Okay.
Okay.
All right.
And Judge, also that second case, I believe it could be if they try that and then you can turn around and try the next one as well.
Yes, Judge. We'd be seeking to stack.
So, Mr. Harmon, also, and I know you've gone over that with him as well, Mr. LeBlanc, that if you're found guilty in both of the cases, because those are different offense dates, that the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
Oh, so it would be stacked, not concurrent?
It would be up to me. So it depends on, if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question, it's a court question. Okay. The plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time if you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. Does that make sense?
Yes, ma'am.
Okay. And you want to go to trial?
Yes, ma'am.
All right. We'll get it set for trial. Then you can go back with the bailiff. Good morning. Are you Joseph Roberts?
Yes, ma'am. Good one.
Good morning. This is 20-34226. Mr. Roberts, looks like you were on probation for the felony offense of driving while intoxicated, and that you were placed on probation November 30th of 2020. That was a 7-year term in prison that was probated for 7 years. Some of the allegations, it looks like there is an additional driving while intoxicated charge from April 26th of 2026. Curfew issue, operating a vehicle without an ignition interlock device, and then some minor fees. Mr. Nix has filed a motion asking that I set bond in your cases. Currently, there is no bond. He's also handed me, it looks like there was a 30-day treatment at Level Up Treatment, Texas, that you went to April 26th through May 29th of this year. Mr. Robert, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Mr. Nix?
Your Honor, we'd ask that the court set a reasonable bond. My client's willing to forfeit his right to drive. He would wear a scram device, comply with any curfew set by the court. As the court can see, He did not have any issues on the probation for several years until he picked up this new offense. It was not his vehicle. There were several other occupants in the vehicle, which would explain why he wasn't complying with the interlock device. He obviously knows that he made a pretty terrible mistake. And if the court will acknowledge, just 3 days after his arrest, he voluntarily did a month of inpatient rehabilitation. Also, I'd like the court to take knowledge of, and although I didn't put it in my motion, I think we made the court aware with the district attorney. His daughter was brutally murdered about 10 days ago now, somewhere around there.
About 2 weeks.
About 2 weeks ago. His daughter's funeral is this Saturday. She was the victim of one of our homicides here in Beaumont out of a domestic violence situation with what appears to be a boyfriend or ex-boyfriend. He'd like to, be obviously on bail so that he can attend his daughter's funeral. He would adhere to any recommendations, anything that the court requires of him of his bond. He's also just been accepted into an IOP program where he will be doing counseling therapy for alcohol substance abuse. As part of that program, they do random alcohol and drug tests. This is something that his insurance offered him after finding out about his daughter. So not exactly related to the DWI, but it's related to finding out that his daughter was murdered in the way she was murdered. He's taking advantage of that. Obviously, he doesn't want to have an episode where he falls off given what his family's going through. He is not the sole provider of his family, but he is the main provider of his family. They have 2 homes, one home that they live in, another home that they haven't been able to sell. So they have 2 mortgages to pay for and bills. Is that correct, Mr.
Yes, sir.
And right now I'd ask if Mr. Roberts can give more details to the IOP than I might be able to. Can you explain to the judge?
What's the name of it, or where is it? What's it through?
It's Trust Health.
Trust.
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 Yes, ma'am. We do 3-hour sessions, 3 days a week.
Is it on?
That's a group.
Is it on?
I do it virtual. I do virtual. Yes, ma'am. They do the random drug screening once a week, and we get a therapy session with a counselor also throughout the week.
How do you do your random drug screen?
They send an Uber and bring me to Quest on 9th Avenue.
Have you already done one of those?
I have one set up for tomorrow.
Okay.
Yeah.
Where do you work?
There you go.
With Bechtel, Environmental Safety and Health Representative with Bechtel. For our LNG.
So how would you get to and from work and things like that if you're not going to drive?
Yeah, my nephew also works out there, same shift, so I can ride with him.
Okay. Just for the record, I am reviewing the court's file, and part of that does include the probable cause affidavit for the new driving while intoxicated. I was looking to see, but I don't know that it's.
It's not yet been received, Your Honor. Testing has not yet been completed.
I was trying to also see, do you have a copy of that previous pre-sentence report?
I had it on my computer earlier, Your Honor. I can pull it back up.
Ours didn't, because it's an older case, it's not in here. Okay, thanks, ma'am. I guess an issue that I have that we're going to have to talk about. So Mr. Roberts signed a no driving agreement with probation March 19th. And then the allegations are that a month and a week after when this happened, he was driving. So he'd already told someone and signed an actual document saying he wasn't going to drive. So obviously the argument of I'm not going to drive gives me some concern because you already. We've been there, done that.
How many set of keys do you own?
Man.
No, to your
No,
car.
oh, I have one, my wife have one.
For the same car?
Yes, sir.
We'd be willing to turn over both sets of keys.
Wasn't driving his car on this date.
Fair enough, Judge.
So I'm not saying I'm not going to set it a bond, but these are the concerns that obviously, there was something going on that I'm not quite sure about, but obviously there was something going on for there to be a no motor vehicle drive form
Yes, ma'am.
signed a month before. So there were some concerns already.
I have previous PSI.
Sounds like it's coming as well over here. Thank you, Mr. Nichols.
You take it.
Mr. Nichols, what's your position?
Judge, I'd reviewed Ms. Molfino's email correspondence with the court and with Mr. Nix talking about her position on this case. We are not opposed to a reasonable bond being set. Obviously, we have concerns, same as the court, with the driving. I believe a scram will take care of any concerns about substance abuse, but there's just not an easy way to be completely certain about the driving. Given the circumstances, given his willingness to do what he's already done and what he's going through, that's why the state does agree for a reasonable bond in this case, Your Honor.
Okay, so Mr. Roberts, I want to make sure you understand, I'm going to set a bond, and if you make that bond, there will be some very specific conditions. Some of those conditions are conditions you already have on the probation. At this point, I understand that you're going through something very traumatic in your life, which tends to lead for people who have substance abuse or alcohol issues for those to get worse. If you don't take advantage of this opportunity while you're out on bond, I can assure you, you're not going to get any opportunity. You're going to be back in jail and you're going to be looking at going to prison for the 7 years that you've already agreed to on that underlying case and who knows what on the other. So this is make it or break it, going to prison type thing, even though it's just a bond. Do you understand?
Yes, ma'am.
So what I'm going to do is grant the motion to set a bond in cause number 20-34226. I'm going to set the bond at $25,000. I am going to order as a condition of that bond that you wear a scram device at all times. If there is a positive alcohol screening, I will know about it. There will be a warrant. There will be no bond, and we'll be looking at that 7 years. It's that simple. Also, as a condition of that bond, you are not to drive any vehicle ever, period, under any circumstance. If you're with people and they're drinking, then you're not the one that drives. Y'all walk, y'all get an Uber, you do something else. You understand? Also, I am going to order as a condition of your bond that you, and really I want it to be a condition of probation as well, to modify your conditions of the probation you're currently on, to order that you can continue that program, the IOP, through Trust Health. I want proof of that, verification of that, since your probation officer each week or whatever you can do. If it's online, you should be able to print something out to send to them to show that you're doing the 3-hour meetings, as well as any drug or alcohol screen that you get done. You need to get those results also to your probation officer. Okay.
Yes, ma'am.
So that'll be a condition of bond as well as your probation. Any other conditions that I didn't cover?
Those are the ones that I was concerned about. I think that'll cover it.
Okay. All right. So what we'll do, if you make that bond, you'll have another court date set. Stay in touch with Mr. Nick. He'll let you know when you need to be back here and in court. And again, whatever you need to take care of to keep yourself doing the right thing, going through what you're going through, you need to make sure and get that done, because being in prison won't help the rest of your family. Okay. All right.
Thank you, Judge.
Yes, sir. I'll shoot a message over.
Thank you. I appreciate it.